A three-judge panel of the Fifth Circuit Federal Court of Appeals Wednesday rejected a suit brought by multiple state attorneys general to block the Biden administration from hiking its utterly arbitrary, make-believe cost of carbon. A cost, so-called, that it plans to use when calculating numerous federal regulations and fines for breaching, yeah, you got it, federal so-called climate change edicts. The states involved in this suit were Alabama, Florida, Georgia, Kentucky, Mississippi, South Dakota, Texas, West Virginia, and Wyoming. And as the Associated Press reports, quote, the unanimous decision by three judges on the Fifth U.S. Circuit Court of Appeals in New Orleans was the latest defeat for states challenging the Biden so-called cost of carbon policy. It leaves the administration to continue using a damage cost estimate of about $51 per ton of carbon dioxide emissions as it develops environmental regulations. That estimate is under review by the administration and could increase. This, of course, assumes a lot that is not assumable. First, it assumes that anthropogenic climate change is happening, a claim that not only has not been proven, but has at its root impossible to compare temperature readings from centuries ago versus manipulated ground readers today. Many who have pushed the claim that man's use of petrochemical fuels has caused anthropogenic climate change also have been caught in multiple attempts to manipulate data, or they've been unwilling to produce their original data in court. Second, carbon emissions are associated with productive activities. Without any hard science to show that it's harming people, the net benefits or losses incurred by the use of so-called fossil fuels have to be determined by real free market participants. The costs involved have to be based not on some spurious, made-up government notion of harm that they haven't proven, but on normal market bases of costs for exploration, retrieval, refining, transport, and wholesale and retail expenses tied to the process of sales. Market participants determine their goals, they determine their incentives, and they determine their marginal losses and profits, and they operate within them. Third, if one wanted to claim that the use of petrochemicals causes harm, then one has to be direct about it and proceed according to something I often mention for very important reasons. They have to proceed according to the process of bringing a tortious claim for damages. The harder politicians push for the power to arbitrarily impose limits and fines and carbon cost numbers and restrictions on people who have not been shown to have brought direct harm to another real person, the more imperative it is that people understand the concept and original history of common law torts. And this means understanding that in original British common law, a tort was a legal claim for recompense or reparations when one believed he or she had been harmed or his property had been harmed by somebody else. That claimant had to show harm, and then the parties would face each other before a jury. By definition, the state is not a person and cannot bring suit for damages. Likewise, the state can't morally preempt or prohibit private peaceful action. And then even after some party might bring a tortious claim and win against another person, well, such a victory wouldn't allow the state to prohibit future private parties from engaging in the same kind of peaceful action. Every case of tort harm has to be handled separately, party to party, and then harm has to be proven, or else state power is going to end up being used arbitrarily to play favorites, to block certain kinds of behavior or favor certain kinds of behavior, which is precisely what the Biden administration is doing with this obscene carbon cost pantomime. As the AP notes, quote, the Biden cost estimate had been used during former President Barack Obama's administration. President Joe Biden restored it on his first day in office after the administration of former President Donald Trump had reduced the figure to about $7 or less per ton. Man, they sure do assume a lot, don't they? But why didn't the state's attorneys general win? Well, curiously, that brings us to what could be the most ironic twist in this tale. The AP reports that after some court movement back and forth with various appeals and maneuvers, this three-judge panel ruled that the states didn't have standing because they couldn't show, get this, harm. Now let that sink in. Quote, on Thursday, the appeals court dismissed the case, saying the challenging states had no standing to sue because they had not shown that the regulations caused the economic harms their lawsuit cited. That's right. The judges of the Fifth Circuit offered a decision that actually mirrors the old personal injury tort system. Which brings us to the biggest irony of this whole thing. What we have here is a panel of judges ruling that these state attorneys general can't bring suit because they can't show they've been harmed by arbitrarily invented costs the Bidenistas are intent on imposing over carbon, which itself the Bidenistas can't show causes any harm. And I have to say, as we see this federal level fraud, we have to note that this cost of carbon nonsense already is being used by 12 northeastern states to engage in what they call the Regional Greenhouse Gas Initiative, or RGGI. It's a coercive trading of carbon credits, wink wink, system that sees the participant governments ready to apply fines to businesses if they don't adopt expensive climate and carbon ameliorating technologies, and then allowing those that do comply to sell their climate credits. Now, obviously, they're going to be selling them to the ones that can't conform. And it's all based on a zero bankable science option and on zero principles of tort law. And it favors big corporations at the expense of those that are smaller and have much slimmer margins. And keep in mind that the Federal Reserve also already has asked the nation's 6 biggest banks to produce their own list of climate costs. Yeah, the Fed appears ready to include that list in its environmental social governance model to be part of its utopian imposition of, you got it, a central bank digital currency, CBDC, that might be coming before year's end. The big government politicians want to manipulate markets, pretend that peaceful activity is dangerous, and control our behavior with an endless parade of brickbats and hobgoblins, even as they actually represent the biggest threat to our liberty and our livelihoods, and as they play favorites with corporate interests by handing them pork and schemes like the tragically titled Inflation Reduction Act. And this is just the beginning. More disastrous government-forced change is coming. And this absurd court ruling tells us that the pushers of all of it have our liberty in their crosshairs. We must be vigilant and try to spread the word. Thank you for being part of this great circle of friends, this great group of kindred spirits. We'll see you at Rumble, where they don't censor us. Remember the MRC-TV channel at Rumble. It's growing by leaps and bounds. You can also find us over at YouTube, yes, where they do censor us. And please offer your comments there and make sure you are still subscribed. And you'll find us on TikTok, on Instagram, on Twitter, on Parler, and at Facebook. And if you get the opportunity, please visit MRCTV.org. That's MRCTV.org, where while you're there looking at what the whole team has to offer, please consider donating to the Media Research Center. I can be found on Gab as @GardnerGoldsmith and on Twitter as @GardGoldsmith. Thanks so much for watching, everybody. For MRC TV, I'm Gardner Goldsmith.